Welcome to Stock Option Counsel. I'm Mary Russell. I'm an attorney, and I counsel individuals on their stock options and other equity compensation. I sometimes work with founders who are joining a startup that is already represented by company counsel, which is the only way to join a startup. But they want to also know about their personal interests, and they want their own counsel to take a look at their documents and talk them through the issues. So I'm going to run through for you today a few of the considerations that I work with on clients in this situation to protect their personal interests. The first is to make sure that the company has counsel engaged to prepare the company structure and the documentation. This is not kind of a homemade legal work project. If you're going to put your time into joining a company like this and creating a product, it makes sense to get it done right from the beginning. Once that basic point is established, then people want to make sure that the equity split is set. Either if they've already set it, making sure that the numbers add up so it is as agreed. But for some clients, I also work with them on the question of what would be the right split in this situation? How should we divide the equity among the group? I think the classic is equally. And you'll hear that advice more commonly than you would think, because people really think a lot and lose sleep over what's fair within a group. It's almost like siblings and rivalries and those sorts of things. So based on that, you'd think there would be some important model that everyone uses for dividing equity. You'll see some of these complicated models online. But if you ask people that regularly counsel startups and have seen these start to finish, the most common advice that you'll hear is to divide the equity equally among the founders. So if you want the simple one-off answer, that's it. But of course, I work with people on more nuanced situations than that. The second point that's on the mind of founders is acceleration upon change of control. That's a fancy expression for what happens to my unvested shares if the company is acquired. So the most favorable would be 100% single trigger acceleration upon change of control, which means simply if your shares or any portion of your founder's shares are unvested at the time of an acquisition, they would all simply vest at an acquisition. The second level would be double trigger upon change of control, which means that two things need to happen to trigger acceleration, meaning speeding up of the vesting of your unvested shares. Those two triggers are there needs to be an acquisition, and after the acquisition, the individual is either terminated without cause or leaves for good reason. Like they're asked to move more than a certain number of miles away or something like that, or their salary is reduced or their responsibilities are reduced. Those are all things we think of as good reason. So the heavily negotiated points on that would be what percentage of the equity would vest in that situation. Sometimes the offer is 50% rather than 100% of unvested equity would vest in that situation. On the definition of cause, the founder would want the definition to be very narrow, so it would only apply if there was a sort of a bad actor, almost criminal situation going on, whereas sometimes you see the offered language for cause include some kind of performance metric, which should not be in a cause definition in this context. Then also you'd be negotiating the definition of good reason, and also the sort of procedure that would have to happen for you to take advantage of a good reason definition and have your equity accelerate. Now, one thing I've been seeing occasionally, and it's more likely for later stage founders who are treated more like an employee when it comes to their equity terms, is that I'll see a clawback for vested shares in the founder's stock purchase agreement. This is a total deal breaker. Your vested equity should be vested even if you leave the company. So I would be on the lookout for that if you're reviewing your founder stock agreement. It's very unlikely to be there, but I've seen it a few times in the last couple of years, and so I want to call that as an issue. Finally, there's the tax structuring of restricted stock purchase for founders. There's an opportunity to have very favorable tax consequences by purchasing the shares up front and filing an 83B election with the IRS. Now that has to happen within a very precise 30-day deadline. You sometimes see people miss this because it is the founder's responsibility to take care of it. Finally, there's a special tax code provision called qualified small business stock. And there's not much to do up front on this point, but down the road, if you've held the shares for 5 years and certain company requirements have been met, especially assets of the company during that period or at the founding of the company or purchase of the shares, then you might be eligible, under the law today, you might be eligible for 0% federal tax rates on all of your gains. That's just something to keep in mind about the desirability of restricted stock for founders and making sure that that tax structuring is handled very precisely when you get started. So thank you for watching today. I'm Mary Russell, and I counsel individuals on their equity compensation. I'd be happy to hear from you through stockoptioncounsel.com. Thank you.